Good morning to our participants in the US, Brazil, and Latin America. Good afternoon to our participants in Europe, and good night to our participants in China. I am Juliana. I'm Regional Manager for EXIN in North America, and we are here today to present this webinar comparing the two data protection laws in the US, CCPA, and Europe, GDPR. Márcio Cots is our presenter. He is our trainer and partner for the GetGlobal International. He is also an European data protection lawyer working with his law firm in the New York City, and also a cyber law specialist by the Harvard Law School. Márcio, if you could start your presentation.
Thank you, Juliana, for introducing me. Hello, everyone. As she said, my name is Márcio Cots. I'm a European data protection lawyer working outside the US for Cyber Law Studio. Cyber Law Studio is a law firm based in New York City. And I'm also the Chief Operating Officer for GetGlobal. For those who don't know what GetGlobal is, GetGlobal is an international organization that assists professionals and companies aiming to comply with personal data protection regulations, providing great opportunities for people who want to change their lives or improve their professional careers through study, analysis, and especially through the experiences of those who have great knowledge about the subject. GetGlobal is also an official EXIN training provider, training professionals to become global DPOs, data protection officers. And today, we will compare and draw a parallel between the GDPR and the new CCPA. But first of all, a short disclaimer. I'm not an American lawyer. Therefore, the content of this webinar is intended to convey general information only and not to provide legal advice or opinion. The content of this webinar and the publication and display of the information in this webinar should not be considered a legal or tax advice under any particular circumstances. The information presented in this webinar may not reflect the most current legal developments. No action shall be taken based on the information contained on this presentation, and we disclaim all liability with respect to actions taken or not based on all or part of the content of this webinar to the fullest extent permitted by law. A licensed lawyer should be contacted for advice on specific legal issues. Well, now let's start our webinar. It's going to be a lot of information, so try to not get bored and stay tuned. But before we start drawing a parallel between the GDPR and the new CCPA, let's take a look at the situation of the new and upcoming data protection regulations in some parts of the world. There are two major privacy laws coming into effect this year, as most of you know. The CCPA, which took effect on January 1st, 2020, and the Brazilian General Data Protection Law, which will take effect on August 16th, 2020. Besides these two major data privacy laws, there are some protection bills being introduced in some different parts of the world. The Nebraska Consumer Privacy Bill and the Virginia Consumer Privacy Bill, the two CCPA-like regulations. And there is also the brand new Washington Privacy Bill, a more GDPR-like regulation, which is not here in our presentation because it has just been introduced as a bill. It was introduced as a bill 2 days ago. But the interesting thing about this bill is that it's a more GDPR-like instead of a CCPA-like regulation. The bill proposes, though, the Washington Privacy Bill proposes strong consumer protection that goes beyond the California Consumer Privacy Act, as I said. It includes provisions on data minimization, purpose limitations, privacy risk assessments, anti-discrimination requirements, and limits on automatic profiling that other states' laws do not. There is also the European Union e-privacy. The e-privacy regulation is a proposal for greater regulation of electronic communication within the European Union in order to increase privacy for individuals and entities. And we also have the India Personal Data Protection Bill and the New Zealand Privacy Bill, not yet in force. Great. Now, jumping into the subject of our webinar, the first question that we have to answer is, what is the CCPA? Well, the California Consumer Privacy Act of 2018 was signed into law on June 28th of this year, amended in the form of Senate Bill 1121 on September 23rd, 2018, and it has been amended and it has become effective on January 1st, 2020. It's the first law that regulates the processing of personal data comprehensively in the US, and it could be an important landmark for data protection regulation in this country. In order to compare the European GDPR and the CCPA, we'll draw a parallel between both legislations, considering their scope, core definitions, legal basis, if applicable, individuals' rights, enforcement, and some other aspects. Regarding the scope, the GDPR applies to any organization based in the European Union for all data processed that makes use of personal data, such as employees, customers, or supply chain. Any organization not based in the European Union, but which offers goods or service to or monitors the behavior of data subjects in the European Union, those also must comply with the GDPR. On the other hand, the CCPA applies to for-profit business that collect personal information of California's consumers with a general annual revenue greater than 25 million US dollars and share personal information of more than 50,000 California consumers. It also applies to companies that get 50% of its annual revenue from selling California's personal information, even if the business is based outside the state. But very important, despite the name, the CCPA applies to a broader class of individuals than the colloquial understanding of consumers. The term consumers is defined under the Act in relevant part as a natural person who is a California resident. Thus, consumers, employees, business contact, and others are protected individuals under the Act. So, a too quick analysis might drive you to a wrong conclusion, because by reading the term consumer, you might think that the scope of the CCPA regarding the people protected is smaller than in fact it is. So it's not just the consumer, but any California resident, which changes a little bit the meaning of consumers regarding the protection coming by the law. In conclusion, to what we have explained it hereafter, there are some differences between the two privacy laws. The GDPR is a little bit broader compared with the CCPA regarding the people and entities who might have to comply with the law, once the CCPA limits its effect to Californians residents' personal data and limits also its effect by the size of the company that is processing the data, or even by the number of California consumers' personal data that is collected by one's company, or even by the annual revenue made by a company by selling California's personal information. So the conclusion is that the scope of both laws are a little bit different. Comparing personal data definitions. Under the GDPR, personal data is any information relating to an identified or identifiable individual. And under the CCPA, personal information is broadly defined, including a number of enumerated categories. In general, information that can be linked to a person, device, or browser will be considered personal information. So in their core definitions, the two privacy regulations are similar. However, the CCPA definition also includes information linked at the household or device level, therefore a little bit broader. Personal data of children. The GDPR only allows processing of the personal data of a child when the child is at least 16 years old. If the child is under 16 years of age, companies must obtain consent from the child's parent or legal guardian to collect and process their data. Under the CCPA, the company must collect opt-in consent in order to sell the personal information of a consumer under the age of 16 years old. Between 13 and 16 years of age, the consumer must affirmatively authorize the sale of their personal information. If the child is under the age of 13 years old, a parent or guardian must authorize the sale of information. Core definition in both laws. In their core definitions, the two privacy regulations are similar in some aspects and different in others. Under the GDPR, processing is any operation or set of operations which is performed on personal data or sets of personal data, whether or not by automated means such as collection, organization, or storage. In its turn, the CCPA defines what processing is, but also what is collecting and selling under the law. So collecting under the CCPA is buying, renting, gathering, obtaining, receiving, or accessing any personal information pertaining to a consumer by any means. Therefore, it covers any type of operation by which a business acquires personal information, be it directly from the consumer or indirectly. On the other hand, selling includes renting, disclosing, releasing, disseminating, making available, transferring, or otherwise communicating personal information for monetary or other value consideration. Note that selling does not necessarily involve a payment to be made in exchange for personal information. And processing is any operation or set of operations that are performed on personal data by either automated or not means. However, the term processing is only used in the definition section. Well, therefore, the GDPR applies the term processing and defines it in a broader way compared with the CCPA. Once under the GDPR, processing is any operation using personal data. On the other hand, the CCPA employs three different definitions, as we saw: collecting, selling, and processing, but in a more restricted way. One more important thing that we have to understand when comparing both laws are the differences between the controller under the GDPR and the businesses under the CCPA. Controller is an individual or a business, public authority, agency, or other body which alone or jointly with others determines the purpose and means of the processing of personal data. Businesses are the entities that qualifies under the requirements hereafter presented, such as being for-profit businesses that collect personal information of California consumers with general annual revenues greater than 25 million US dollars and share personal information of more than 50,000 Californian consumers. It also applies, as we saw, to companies that get 50% of its annual revenue from selling California's personal information. Different than the GDPR, the CCPA is restricted for profit businesses. And as we saw, the GDPR defines controller as an individual or a business, public authority, agency, or other body. GDPR processor means an individual or business, public authority, agency, or other body which process personal data on behalf of a controller. Under the CCPA, a service provider is a for-profit entity that processes information on behalf of a CCPA-covered business. Again, differently than the GDPR, the CCPA is restricted for profit business. These two terms that you are seeing on the screen are only found in the GDPR: profiling and anonymization. Profiling means any form of automated processing of personal data consisting on the use of personal data to evaluate certain person aspect relating to a natural person, in particular to analyze or predict aspects concerning that natural person's, for example, performance at work, economic situation, health, personal preference, and so on. Anonymization is the processing of personal data in such a manner that the personal data can no longer be attributed to a specific data subject without the use of additional information. Talking about the legal basis are terms only found in the GDPR. And what is a legal base under the GDPR? It's basically a list of situations on which the processors can process personal information. The GDPR has 6 legal bases for processing of personal data. If the processor does not fit any of these legal bases, it's lawful. It's unlawful. Here we are going to talk first about 3 different legal bases, and on the next slide we are going to see the other 3 presentations. The other 3 legal bases. Consent. The data subject has given consent to the processing of his or her personal data for one or more specific purpose. Contract. Processing is necessary for the performance of a contract to which data subject is part or in order to take steps at the request of the data subject prior to entering into a contract. Vital interests. Processing is necessary in order to protect the vital interests of the data subject or of another natural person. The other three legal bases: public task, legal obligation, and legitimate interests. Public task. Processing is necessary for the performance of a task carried out in the public interest or in the exercise of official authority vested in the controller. Legal obligation. Processing is necessary for compliance with a legal obligation to which the controller is subject. Legitimate interests. Processing is necessary for the purpose of the legitimate interests pursued by the controller or by a third part, expected where such interests are overridden by the interests or fundamental rights and freedoms of the data subject to which require protection of personal data. In particular, where the data subject is a child. Well, as we said, the CCPA has no list of a legal basis of which businesses can collect and sell personal information. It only provides that businesses must obtain the consent of consumers when they enter into a scheme that gives financial incentives on the basis of the personal information provided. The consumer can opt out of having their personal data sold, in which case a business will not be able to sell the data for which it has explicit consent. Okay. Now we are going to draw a parallel between the individual's rights stipulated in both privacy laws. Comparing the right to be informed in the GDPR and the right called notice to consumers in the CCPA, we'll see that in the GDPR, the individuals have the right to be informed about the collection and use of their personal data. It's a key transparency requirement under the GDPR. You must provide individuals with information including your purpose for processing their personal data, your retention period for that personal data, and whom it will be shared with. Under the CCPA, businesses are obligated to inform their consumers at or before the point of a collection of what categories of personal information they're collecting, including the purpose of the collection. It means that California residents have the right to know what a business collects and how and why they use the personal information collected. Businesses must give consumers notice every time they begin collecting new forms of personal information, new categories, and if they start collecting personal information for new purpose. With that, unlike the GDPR, the CCPA does not distinguish between the notice for collecting information directly from individuals and the notice when information is obtained from other source, for example. Now, right to erase versus a right to request deletion. Right to erase or to be forgotten has a provision in the GDPR the GDPR introduces a right for individuals to have personal data erased. Individuals can make a request for erase verbally or in writing, and companies have 1 month at maximum to respond to a request. The right is not absolute and only applies in certain circumstances. And right to request deletion under the CCPA means that a California resident can request that a business delete the personal information it has collected on them in the past 12 months. If the request made by the consumer can be verified, the business is legally required to delete the consumer's personal information from its records and direct any service providers to delete the data too. As we see, both the GDPR and the CCPA allow individuals to request the deletion of their personal information unless exceptions apply. It's worth noting that some exceptions are the same under both laws. For example, freedom of speech, processing of personal data for research purpose, if erase of the data would impair the object of the research, are some examples of exceptions under both privacy laws. Regarding the right to data portability, the definitions are quite the same in both laws. In the GDPR, the data subject shall have the right to receive the personal data concerning him or her, which he or she has provided to a controller in a structured, commonly used in machine readable format, and have the right to transmit those data to another controller without hindrance from the controller to which the personal data have been provided. And the CCPA states that when businesses provide data electronically to the consumer following an access request, this data should be sent in a portable and readily usable format that allows for the transmission of this data to third parties without hindrance. The CCPA states that consumers can exercise this right free of charge. There may be some instances where a fee may be requested. So just in some situations that might happen. These three rights that you see on the screen are only found in the GDPR. Right to access, right to restriction of processing, automated individual decision making. The right to access is the individual's right to access their personal data. They can make a subject access request verbally or in writing. The data subject shall have the right to obtain from the controller confirmation as to whether or not personal data concerning him or her are being processed. And where that is the case, access to personal data. Right to restriction of a processing is the data subject's right to obtain from the controller restriction of processing where one of the following applies. So there are some situations that we are going to explain to you right now. The accuracy of the personal data is contested by the data subject for a period, enabling the controller to verify the accuracy of the personal data. Second, the processing is unlawful and the data subject opposes the erase of the personal data and requests the restriction of their use instead. Third, the controller no longer needs the personal data for the purpose of the processing, but they are required by the data subject for the establishment, exercise, or defense of legal claims, for example. And the last one, the data subject has objected to processing pursuant to the Article 21.1, pending the verification whether the legitimate grounds of the controller override those of the data subject. The GDPR has provisions on automated individuals' decisions making and profiling. Automated individuals' decision making, solid by automated means without any human involvement, and profiling, automated processing of personal data to evaluate certain things about an individual. Profiling can be part of an automated decision-making process. Two more rights which we will only find in the GDPR. Right to rectification and right to object. Right to rectification, which stipulates that the data subject shall have the right to obtain from the controller without undue delay the rectification of imprecise personal data concerning him or her. Taking into account the purpose of the processing, the data subject shall have the right to have incomplete personal data completed. And the other right, the right to object, under this right, the individuals have the right to object to the processing of their personal data in certain circumstances. Individuals have an absolutely right to stop their data being used for direct marketing. In other cases where the right to object applies, you may be able to continue processing if you can show that you have a compelling reason for doing so. Great. Now let's take a look at three different individual rights foreseen only in the CCPA. Right to opt out, right to equal service and price, and right to disclosure. Right to opt out. Under the CCPA, consumer right, California residents have the right to request that a business stops selling their personal information to third parties. If a business is able to verify the request as coming from a consumer in question, they are obligated to stop any further sales of that consumer's personal information to third parties. Both regulations guarantee a right for individuals to ask organizations to cease the processing and selling their data. The CCPA requires that a link with the title "Do not sell my personal information" is provided on the homepage of the business. Additionally, the CCPA provides that any third party that received personal information pursuant to their selling can only further sell that personal information if consumers are provided explicit notice and the opportunity to opt out of this subsequent selling. Under CCPA, consumers can only opt out of the sale of personal data and not the collection of other uses that do not fall under the definition of selling. That's why the law has a specific definition for selling. By contrast, individuals can object to any type of processing of personal data under the GDPR, either by simply withdrawing consent or by objecting to processing that in is based on legitimate interest or on necessity for a task in public interest, for example. CCPA right to opt out of personal information is absolute, while the GDPR general right to object has a specific exception where the controller demonstrates compelling legitimate grounds for the processing that override the rights and interests of the data subject. Right to equal service and price. Under the CCPA consumer right, California residents are protected against any discrimination that a business might subject them to based on the exercising of their CCPA rights. This means that if a consumer decides to exercise their right to opt out of having their personal information sold by a business to a third party, the consumer is protected by the CCPA rights from getting lower quality service or higher price from that business because of their decision to opt out. Right to disclosure. Under this CCPA consumer right, California residents have the right to request that a business disclosure what personal information they have collected on them in the past 12 months. Upon the receipt of a verifiable request, a business must disclosure to the consumer the categories of personal information collected, the categories of sources from which the personal information is collected, the purpose of collection, the categories of third parties with whom the data has been shared, and the specific pieces of personal information collected. As part of this CCPA right, consumers have the right to get a free copy of their personal information disclosed in a usable and readable format. California residents also have the right to have at least 2 ways to request disclosure of their personal information, including a toll-free telephone number or a link or email on the business website. Now, the last part of our webinar, enforcement. Comparing the enforcement of both privacy laws is quite easy. The GDPR has fine of up to 20 million euros or 4% of the worldwide revenue, annual revenue of the prior financial year per infringement, whichever is higher. On the other hand, in the CCPA, the California Attorney General's Office assesses eligible violations and can bring legal action with fines up to $7,500 for each international violation and $2,500 for each unintentional violation. Well, as you all have noticed, it's mandatory to any professional that might want to be a data protection officer working for an international organization to have knowledge of a different data privacy regulations. The GDPR, the CCPA, and the Brazilian LGPD require that any organizations appoint a data protection officer. And research estimates that more than 75,000 DPOs will be required in the coming months. So if you want to be prepared and if you want to be a global DPO, you must know all of these international regulations. And it is with this goal in mind that GetGlobal addresses its boot camps. The next GetGlobal bootcamp will be held in Lisbon, Portugal, from February 24th to 28th. During a week, the professionals will take classes on all aspects of the European GDPR through two programs, the fundamental European GDPR and the advanced European GDPR. They will also learn about the CCPA and its fundamentals in everything that is related with the Brazilian LGPD. One of the instructors will be Fujitsu's DPO in Portugal. He will be able to share with the participants his role as a DPO in a multinational company. So if you want to know about these important international regulations, and if you are interested in becoming a global DPO, get in touch with GetGlobal and take your place at the Lisbon Bootcamp. One more thing, be aware that after the bootcamp in Lisbon, GetGlobal next edition will be in New York City again. So if you are interested in any of the two bootcamps, send us an email. And I almost forgot to say that all the people who have participated in this webinar will have a $750 discount on the boot camp. So that's good news for those participants. Now, Juliana, I think we have time for 2 or 3 questions, if there is any. So I'm available here.
So if anyone has any questions, you can type it in the chat. Meanwhile, I would like to just thank you all for being in this webinar. I would also like to say, if you don't have the opportunity to send any questions now, you can always contact Márcio. The details are on the screen. We also would like to say that for those who participated of the webinar, or even those who could not participate of the webinar but were registered, we are going to send a record of this webinar to you, so you can still get in contact with Márcio and take any doubts that you might have. I haven't received any questions for now. I think people are still sinking in the information, but you can always contact Márcio or EXIN support at exin.com, and we will be glad to answer all your questions. Thank you very much for your participation.